All right, we're at 6:03. So we're going to go ahead and get started. My name's Maya Van Rossum. I'm the founder of the Green Amendments for the Generations organization and movement. And I'm thrilled to be joined by Shaylin Parker, who works with me in helping to advance this movement and working with all of you. She's a member of the Green Amendments team and a really great hard worker, and many of you have interacted with her. And I want to thank so many of you. I've been calling out names, right, who are active on advancing green amendments nationwide. Really quick, to make sure we're all on the same page, right? A green amendment is not any kind of constitutional amendment. It's a carefully crafted amendment added to the Bill of Rights or Declaration of Rights section of a state constitution and recognizes and protects the rights of all people to pure water, clean air, a safe climate, and a healthy environment. And the best green amendments ensure that government officials of the state have a very clear constitutional obligation to protect our state's natural resources and to do so generationally. In all green amendments, these rights and entitlements must be protected equitably for all people and all generations. And there are a lot of other special elements, but we won't dive into them. Those are the basics. And we're here as part of our National Green Amendment Day celebration. Sunday was National Green Amendment Day. It was wonderful. On that day, we launched our community our community arts gallery, and people from all over the nation have donated art, poems and songs and visual art. Somebody made a special quilt by hand, all of which were inspired by Green Amendment protections and or beautiful Mother Nature. And so if you haven't had an opportunity on social media or gone to the website to take a look at this community art gallery, I think that you will be inspired. I think this is going to become a regular part of our National Green Amendment Day celebrations because it is so amazing what has been shared with us. But tonight, we have every year as part of National Green Amendment Day, for those of you who have been part of the movement, every year we try to have an educational component, really to advance forward and lift up all of our knowledge about the power and importance of green amendments and this special constitutional pathway for environmental protection. And so tonight, we are going to have a pre-recorded interview with Professor Robert Williams, who is a nationally recognized expert and author on the power and importance of state constitutions for advancing social values, including protection of our environment and our environmental rights. So I think it's going to be a powerful session. I do just want to highlight that since we founded this Green Amendment movement just over 10 years ago, not only have we been an important part of empowering or witnessing the empowerment of the two existing green amendments that existed at that time in Pennsylvania and Montana, but we've also been responsible for inspiring and helping to secure a green amendment in the state of New York and for inspiring green amendment proposals in over 20 other states from coast to coast and in the Hawaiian Islands. So it's a powerful movement making powerful progress because it brings transformational change. And with that, we're going to go ahead and start the pre-recorded interview, but let you know I will come back on after the interview for anybody who might want to have some questions or engage in any live discussion for a little bit. But with that, here we go. Professor Williams, I'd like to thank you so much for joining me this morning to talk about the essential qualities and elements of state constitutions that make them so valuable for protecting fundamental values here in the United States of America.
Well, I'm really glad to be here because this is a very important topic. Thank you.
So can we just start by you telling our audience a little bit about yourself?
Yes, I did my higher education in the state of Florida, where I grew up. And through a fluke, I got a job in the state legislature between college and law school. That was the summer of 1967. And it just happened that the legislature stayed in session all summer and rewrote the old 1885 state constitution. And I was this political science graduate with pink shoelaces asking, why is it so long, and all of these sorts of things. But so then I went to law school and I wrote my law review article about some of the provisions in the new state constitution. When I practiced law in Florida, I used the state constitution in a few different kinds of cases. And when I came into teaching at Rutgers Law School here in New Jersey, I suggested we teach a class on state constitutions, and the faculty agreed to that. So I taught state constitutional law for 40 years at Rutgers Law School, and wrote, lectured, and participated in state constitutional law cases. So it's been a great career.
So you're a true expert, and you're exactly the person I need to talk to help advance the knowledge of our Green Amendments community. I do want to start by letting people know you have a book, The Law of American State Constitutions, and you actually recently put out an updated second edition. And I was wondering why you thought it was important to put out a second edition of the book.
The field of state constitutional law is ever changing. It changes month by month even. You've got 50 states. All of them have their own state constitutions. One of the big differences between the United States Constitution and the state constitutions is the state constitutions are much more easily amendable. So there are a lot of changes almost every election in the text of state constitutions, and then all of the time the 50 state Supreme Courts are deciding cases interpreting state constitutions. So there's a lot of activity in the field, and in recent years, state constitutions have become more essential to the public, particularly after the recent abortion decision that sent those cases back to the states. So there's a lot of activity in this field.
So I want to take a second to go right back to the very basics. Can you tell us exactly what is a constitution?
A constitution is a form of higher law. It's a document that sets forth the rules for the government of a political body. In our case, in the United States, states or the national government. So it's sort of the governing document of these kinds of governments.
So how did state constitutions come to be? When and how were they developed?
It's actually very interesting, and a set of facts that most people are not aware of. Right away in 1776, when we declared our independence, states began writing their own state constitutions. And states like Pennsylvania, Virginia, North Carolina, right away in 1776 wrote their own state constitutions. And the other states followed. And so we had state constitutions here in the 11 years before we had the federal constitution. And in fact, the constitutions of the states served as models for the new 1787 federal constitution.
So the state constitutions then came first.
Yes.
So what was the reason for the creation of the federal constitution, and how did that come into being?
There had been earlier, people would recognize the name, the Articles of Confederation, which was a loose governing document of the 13 original colonies. It was very weak, and events made it clear that that was an inadequate governing document for the new federal government. So the decision was made to call a federal constitutional convention, the famous Constitutional Convention in Philadelphia across the river from us, which then was called to update the Articles of Confederation, but instead it went forward and prepared an entirely new constitution that it then presented to the 13 states.
Who actually, for lack of a better word, or maybe it's the right word, voted the federal Constitution into being? Was it the people or somebody else?
It's a very good question. Definitely not the people. The idea was that the 13 states would call what were called ratifying conventions, where they elected people to go and sit in convention and decide whether they would ratify the U.S. Constitution. So there was no direct election to adopt the federal Constitution, nor have there been any direct elections to adopt the amendments to the federal Constitution.
We'll talk a little bit later about the various ways that state constitutions can be amended, but just in this moment I want to ask you, when it comes to state constitutions, do the people of the state actually vote for that constitution, or is it a similar process that you just described for the federal?
It's quite different, and it has evolved over time. The first state constitutions in 1776 weren't voted on by the people. New Jersey's, for example, was just promulgated by the Revolutionary Congress, early form of the state legislature. 1,000 copies were printed, and boom, that was the Constitution. But very soon, the Constitution-making process in Massachusetts in 1780 developed the model that we use today, a separately elected convention intended only for the purpose of drafting a constitution, not other kinds of state government matters, was invented in Massachusetts, again in 1780, where these delegates were elected to come together and draft a constitution. And then the next very important step was to put the Constitution out for ratification by the people. In those days, it was town meetings in Massachusetts. It wasn't a full-blown election, but very quickly the states evolved a model of a separately elected constitutional convention, which then proposed its draft to the people. And so therefore it was the people that gave legal authority to the Constitution in the states, not at the federal level.
Now, in this modern era, is that constitutional convention approach still used every time a state constitution is to be amended?
Not necessarily to amend a state constitution, but to adopt a new state constitution. That would be required in all 50 states. Interestingly, we haven't had a real state constitutional convention in the last couple of generations. People have, actually it's been referred to as convention phobia. People worry about such a constitutional convention being really simply more politics as usual. And over the last 50 years or so, people in most states and in the country have turned pretty sour on politics. So as a consequence, the only way politically that state constitutions evolve now is through the process of either amendment or revision. But again, we haven't had a state constitutional convention in any state for the last several generations.
So at the state level, are all these government officials subject to the constitutional obligations and limitations in the state constitution, or is only the governor bound?
No, all of them are bound, including government officials who are not designated in the Constitution. Many state and local government officials are not named in the state constitution, but they're still subject to the limitations and requirements of the state constitution. By the way, and they're also subject to the limitations of the United States Constitution.
So all government officials at the state level and the local level within the state are subject to the obligations and authorities of the state constitution and the federal constitution.
Exactly.
The federal government and federal government officials are subject to the federal constitution, are they also subject to state constitutional obligations?
In a word, no.
That was pretty, that was pretty clear. Okay. Also in your book and in your teachings, you talk about the states having reserved plenary powers, not enumerated powers. Can you explain what this is, what this means, and why it's important in terms of how state constitutions are written, interpreted, and applied?
This is a very important distinction between the federal constitution and state constitution. People will remember from high school civics, I think, that when the states came together to form the federal constitution, they actually gave away some of their powers, such as the power to regulate interstate commerce. Back in those days, the states were imposing tariffs on each other. So if goods came from New York to Pennsylvania, they had to pay a tariff. In the Constitutional Convention, they decided that was better power to be exercised by the national government. So they gave up that power. As a consequence, states cannot regulate interstate commerce. And so they enumerated or delegated or listed certain things that the national government could do, provide for the national defense. Some other things that we read today, provide for post offices and post roads. And it's a list of things that the national government can do. And of course, those have been interpreted over the years by the Supreme Court in certain ways. What the states did was they retained all other government power for themselves or to the people, as the Ninth Amendment says of the U.S. Constitution. So when you look at a law passed by the U.S. Congress, you ask the question, does the U.S. Congress have the power to pass this law? When you come to the state legislatures and you see there's a proposed landlord-tenant law, or a proposed criminal law, or a proposed law on how you pass wealth at death, wills and inheritance, you don't have to find someplace in the state constitution that says the legislature can pass such a law. The powers that were retained by the states were essentially all the powers that the British Parliament had. So there's a consequence to this in terms of the legal interpretation of the two different kinds of constitutions. The sort of great questions for the Supreme Court to answer, for the U.S. Supreme Court to answer about federal legislation is there the power to do this? Can U.S. Congress do this? This was a question about the Affordable Care Act, the so-called Obamacare. Could Congress really do that? And so the hard questions are there implied powers that emanate from this list that the U.S. government has. Coming back to the states, there's no question about powers or even implied powers. The big questions are limitations on what the state can do. Like I mentioned, state legislatures can't pass big, beautiful bills. And so the hard constitutional interpretation questions are those about implied limits on government. So a way to simply describe this in shorthand terms is the federal government operates enumerated powers and possibly implied enumerated powers. The state government has, we call plenary or unlimited powers, except as limited by the state constitution. This describes in a way the two different constitutions. When you get to rights guarantees, that's not true. The rights guarantees operate in similar ways.
So when we think about this idea of limitations on the authority of state government, that there's a limitation on government's ability to infringe on free speech rights, for example. Is that because when the people were writing the Constitution, they were kind of like the states were doing with the federal government. The people were saying to the state government, we're giving you power, but not this power and not this power. Is it sort of that? Is that how it works?
That's exactly right. But it's true not just for rights. For example, state constitutions have long articles about how taxation will work. Taxation is one of the central features of the reserved plenary power that states have. And without limits in the state constitution, you could have different tax laws every year. You could have people and businesses could be taxed at all kinds of different rates. So the state constitutions have all kinds of limitations on how that's going to work. Same's true for, let's say, public education. There are a lot of provisions on how big a school board will be and all that. So the legislature can't vary those things willy-nilly. But it's also true, certainly, for the rights guarantees, that those limit how state government can operate.
So you've answered this already, but I just want to put a period on the thought. So I'm going to ask it as a question. Is a state constitution the government of the state telling the people of the state how the government is going to govern over them? Or is it the people of the state telling the government of the state what authorities the people are willing to give to them in order to govern within the state?
This is a great question, Maya. In the first instance, it's the people telling the state government how it's going to operate. To some extent, what it must do and what it must not do. And almost all of the state constitutions, only one or two exceptions, right at the beginning they say the power of the state government emanates from the people of the state. We call it popular sovereignty. It's a little more complicated, though. Once the Constitution is adopted, then it governs the people too, until it's changed. And one of the important features about state constitutions is they're much easier to change than the U.S. Constitution is. But so you have to look at it in the first instance. It certainly is the people telling the government how it is to operate. But once that Constitution goes into effect and is ratified, again, by the people, it does govern the people also.
So once the rules of the road are set, the people are subject to them as well until the people change them.
Yes, and that's popular sovereignty.
So we've touched on this in a variety of different ways. We're going to ask the question in broad strokes, and then we'll see where that leads us. So in what other ways are state constitutions different than, perhaps even more important than, the federal Constitution when it comes to our living our lives?
There are a number of examples of this. One of them is that state constitutions have a number of features that enable the people to make decisions about their own government. For example, most state judges in this country, state judges, are elected in various ways, either partisan elections, sometimes nonpartisan elections, sometimes what we call retention elections, where the judge or justice on the Supreme Court runs against their own record. But they're subject to approval by the voters. That's never true under the federal Constitution for federal judges. There are a number of important ways where the public gets involved in governmental decisions, such as borrowing money. In most states, the decision to make large borrowing decisions is subject to voters' approval, sometimes for environmental projects, for example. Amendments are voted on by the people. Changes to the state constitution are subject to popular sovereignty. Amendments to the federal constitution, rare as they may be, are not voted on by the people. And even in, it's not a majority of the states, but 18 or 20 states, lawmaking functions have been reserved for the people. We call it the initiative and referendum, where signatures can be gathered to put ballot measures to the people, either to pass ordinary laws or in some states to amend the state constitution itself. So these various involvements of the public in their own state government are very different from the processes in the U.S. Government. Another one is the state declarations of rights or bills of rights can be much more extensive than what we know as the first 10 amendments, which is much more famous, of course. But state bills of rights go sometimes 20 or 30 articles or sections on all kinds of things that don't appear in the United States Constitution.
Great lead into the next question. So what makes the Bill of Rights section, or in some states it's called the Declaration of Rights section of the state constitution, special? What's unique about those provisions?
Several things. One is that in most states it comes at the beginning of the Constitution, not as an afterthought as we saw in the federal Constitution. Even Virginia in 1776 passed the first Declaration of Rights before it ever wrote the Constitution. So this was a big deal to the revolutionary generation. But beyond that, again, there's so many more rights in state declarations of rights than in the famous federal Bill of Rights, such as education rights. There are 39 states have a right to remedy for injury. It emanates from the Magna Carta, the 13th century in England. Nothing like it was proposed for the federal Constitution, but James Madison didn't think it was important enough to put in the U.S. Constitution. So there's all sorts of things. And what this does, because state constitutions are easier to amend, don't get me wrong, they're not easy to amend. It's a big deal, but it's virtually impossible at the federal level. But because they're easier to amend, the state declarations have been, to some extent, kept up to date through popular sovereignty again. So women's rights entered into the state constitutional declarations before women were given the right to vote in the 19th Amendment to the U.S. Constitution. New Jersey and 5 other states have a right to collective bargaining put into the state constitutions. New Jersey Constitution, for example, bars segregation in public education in the text of the Constitution from 1947, so relatively, to me that doesn't seem so long ago. So the catalog of rights in state constitutions is very long. It'd be impossible to name them all, but those are a few examples.
Now, you've talked about state constitutions being closer to the values of the people within a state. Can you describe what you mean by that?
I think this goes back to the idea of popular sovereignty. The state constitutions really, they're owned by the people in the sense that they emanate in the first instance from the people. Amendments to them are ratified by the voters. A number of other matters like assumption of debt. In many state constitutions, alcohol regulation is a matter of state constitutional law, and sometimes votes of the people, sometimes county by county in some states. So this idea of the involvement of people makes state constitutions much closer to the people of the state than the U.S. Constitution could ever be. There's another element to it, though. State constitutions are much longer and much more detailed than the U.S. Constitution. I used to have the Alabama Constitution. It's in the library after I retired. It's that thick, amazing level of detail. In a sense, it's inconvenient in some sense, but it does bring the document closer to the people because it's much more involved in their daily lives. They've brought it on themselves, as we discussed earlier, but this leads to a paradox, actually, that's really interesting and sort of a shame. The U.S. Constitution is pretty remote from the people. Most people would not have any access to making a decision in the United States Supreme Court or working on amending the U.S. Constitution, which is almost impossible. But yet most people know about the U.S. Constitution and they know about the United States Supreme Court, yet they can't have any involvement with it. State constitutions are low visibility. Polls have showed about half the people in the United States don't know they have a state constitution for their state. Yet the state constitutions are closer to the people. Citizens of states actually could possibly be involved in a court case in their state Supreme Court. Citizens of state could possibly be involved in a move to amend their state constitution. They are involved in voting for Supreme Court justices or state judges at all, voting on amendments, but yet they don't know about the state constitution. So this has bothered me my whole career.
So, well, you'll love this. So one of the fun things about the Green Amendment movement is not only are the people involved in the actual, the court cases and the advocacy that enforce the amendment and use it, but in all of the Green Amendment states where I'm working, it's the people that I'm working with, right? The actual community members are helping to decide what the language of that state's Green Amendment will actually be. So there's a super level of involvement, and people really have this historic opportunity if they're involved in the Green Amendment movement.
And some of these people, before they got involved in the movement, may not have even known they had a state constitution. But this is the interesting element of state constitutional law. It is accessible to ordinary people.
So one of the things you describe in your book is you describe the federal constitutional rights as being negative and state constitutional rights as being a combination of negative and positive. What do you mean by this?
The famous U.S. Constitutional Bill of Rights is a negative limitation on the federal government and now on the state governments after the adoption of the 14th Amendment. So it says the federal government shall not interfere with freedom of speech and religion. It shall not engage in unreasonable searches and seizures. It shall not quarter soldiers in your house. It can't do this, 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 and this. It's negative in its nature, limiting government. Most of the state constitutional rights guarantees are also negative, but they're also scattered in there, sometimes not in the Declaration of Rights, as I mentioned. For example, the right to public education. Around the turn of the 20th century, states began to put that in the state constitution as a mandate for something that the state government was required to do for the people of the state. So we look at that as positive in nature. It's a mandate for the government to do something for the people. This is also, I think, quite true of the Green Amendments. They're a positive right for people. Workers' compensation, for example, was initially declared unconstitutional because you didn't get a jury trial. So the constitutions this is a feature of state constitutions I'll come back to. The state constitutions were amended to say, yes, there will be workers' compensation. It's okay between the lines, even if there is no jury trial, because we're putting it in the Constitution. That makes it okay. And people have a right to that. Again, a mandate, a positive guarantee for people. So yes, we usually think of rights guarantees as limiting government in certain ways, but the state constitutions have a number of these kinds of positive guarantees for people.
I love that you mentioned the Green Amendment, because the best Green Amendments are a combination of the two. There's a right to pure water, clean air, safe climate, healthy environment that may not be infringed upon, and then there's a positive duty on government officials to protect these rights equitably for all people and to protect the state's natural resources for present and future generations. So what you've talked about is a beautiful demonstration of the valuable qualities in a Green Amendment.
I think the Green Amendments actually represent essentially everything I'm saying here.
I agree with you.
Surprise.
So are there rights in state constitutions that are not found in the federal constitution? And again, you've kind of answered this, but just to really bring it home for people.
Many of rights in state constitutions are unrecognizable to people that only know about the United States Constitution. And this is an ongoing process. Most recently, of course, after the U.S. Supreme Court decided that abortion was no longer a federal right, a number of states have put the right to reproductive health in the state constitutions as a guarantee in the Declaration of Rights. Of course, that's not in the U.S. Constitution. I mentioned the right to remedy, which is a very important guarantee. It's in 39 state constitutions, not in the U.S. Constitution. There's a very interesting clause now being involved. At the time Obamacare was being developed at the federal level, a number of states used the state constitutions to express their opposition to that. And so rights guarantees were placed in state constitutions that said people have a right to make their own decision about their health care. Once Obamacare was declared valid, as a valid exercise of congressional authority, those were, may I use the word, trumped by the by federal law. So they seemed to be pointless. In a fascinating development, the Ohio courts are now deciding whether the right to reproductive freedom is a guaranteed right to decide your own health care. They had put this negative amendment in the Constitution back when one of the political parties opposed Obamacare, thinking it would at least be an expression, and now it's come back. We'll see what the Ohio Supreme Court says, but a very interesting turnaround. So I used to say to my students, just take the state constitution to bed with you and read it, and you're going to think it's going to put you to sleep, but in fact what's going to happen is you're going to go, holy cow, I didn't know this was a constitutional right. So it's a very interesting thing to do.
I think that's good advice. So going back to the positive and negative rights, why are positive rights more appropriate for state constitutions than the federal Constitution?
Well, the question might be more appropriate and more possible. Again, it's almost impossible to amend the U.S. Constitution as a practical matter, particularly now in our polarized politics. But the national Constitution covers the whole country. We have such a diverse country in all kinds of ways, topography, population, all sorts of things. Maybe we don't need positive obligations of the federal government to apply in every part of our country. Some of us wish we could achieve that, but it seems pretty much impossible. But for example, a highly populated state like New Jersey might need something different than a state like Wyoming, which is very sparsely populated. And so take water rights. The state constitutions in the East don't say anything about water rights. Unsurprisingly, the Western states have whole articles in the state constitution about water rights. And in a sense, those are positive rights. You have a right to the river coming from your neighbor's land onto your land not to be polluted, not to be completely diverted to their use so you get nothing. We don't need that in the East. We may start to need it in the East as time goes on, but when the state constitution, when those provisions were drafted, people in the East didn't worry about such things. We worried about canals and regulating canals and railroads and all those things. Out West, you don't see that stuff in the state constitutions. So if you come to environmental provisions like green amendments, they might, and people you work with might see things very differently in a dry, flat, uninhabited state from people you work with in heavily populated, mountainous states with different kinds of environments. So, in a sense, the federal structure of our country, which leaves a lot of decisions to the states, not just about what they put in their constitutions, but their kinds of laws and all sorts of things, makes some sense in a country like ours with this huge expanse of territory and different attitudes and different needs.
Yeah, I love your observation about the Green Amendment, because it's exactly why I'm very clear with people. There's no cookie cutter Green Amendment, right? There are guidelines, there's model language to start from, but every state has its own nuances, priorities, differences, particularities, personalities, and we try to make sure the Green Amendment language reflects those values of that state. So if people want to have a fundamental right recognized and protected, it's really important to accomplish it at the state level.
It is, but it's limited only to that one state. The one positive effect of adopting an amendment in one state is there's a long history in our country of states copying provisions from other states. We saw it very clearly in the westward movement as we started to move right after the end of the Revolutionary War through the whole westward movement. The delegates in those constitutional conventions, there were little books that were published that had all of the state constitutions of the existing states. And though it's clear in history, those people, as the West was conquered, they had these little books in their breast pocket and were pawing through them and copying things from other states. Now that our manifest destiny seemingly has ended, there's still a lot of this learning from, it's true for adoption of laws too, no-fault divorce, automobile insurance reform, a number of things were copied state to state. But the state constitutions are also a product of copying. So amendments like the reproductive rights guarantee get copied. And it should also apply to the Green Amendments, I would think.
So it really is. I think we do often have states saying, well, who else has done this? Where else is this happening? So you're right, in the Green Amendment movement, that synergy between states is really powerful, effective, and frankly, helpful. So it sounds like you think that state constitutions really are an effective mechanism for reflecting evolving public attitudes around societal issues and social issues. Is that true?
That's been clearly demonstrated throughout history, that the state constitutions are available as a technique of lawmaking. We don't think of the federal constitution that way, again, because it's so hard to change. But in the toolbox of state lawmaking, you've got state legislature, passing ordinary laws. You got state courts deciding common law decisions about all kinds of matters. But there's also this availability. It's not easy to do, but to entrench important rules in the state constitution, and that evolves over time. So there are these waves of constitutional change that we see across the country. And so it's no coincidence there was no Green Amendment in the 1890s. It just wasn't on the public agenda, the political agenda at all. If anything, people were despoiling the environment. But you see, beginning in the 1970s, I think that's where the Pennsylvania Clause originated, that this is something that's on the minds of people who want to engage in lawmaking in various ways. And they realize that there is this originally low visibility technique of lawmaking. And some people say, oh no, you really shouldn't put policies into the state constitution. You should reserve the state constitution for important matters. And the answer is, well, we happen to think certain things are pretty darn important, and they're important enough to be elevated above ordinary lawmaking in the helter-skelter politics of state legislatures. Not to completely preempt state legislatures. Amending the Constitution doesn't eliminate the function of a state legislature or the state executive through executive orders and various techniques of taking care that the laws be faithfully executed, nor the function of the judiciary. All of those are still preserved, but you have sort of fundamental popular adoption of a governing idea that affects all these other seemingly ordinary lawmaking functions.
And then those other branches become responsible for helping to give application and life to the new concept in the Constitution. And in this case, it would be environmental rights protection.
In a positive sense,
right.
And they're also subject to brand new limitations on what they could otherwise do. So again, it's this dual kind of purpose. It's not true for all constitutional rights, but it's true for some of them, particularly the positive rights. They have a limiting function and a mandating function.
So I'm going to hop to a question because you've answered it, but again, I want you to really put a period on it. Some of the opponents of green amendments say, well, if you pass a green amendment, you're giving all the power for determining environmental protection to the courts, and you're taking that power away from the legislative branch. And you're not just giving it to the courts, you're giving it to one judge who's going to decide a case. What's your reaction to that kind of characterization?
I think that's demonstrably false, because putting a clause like this in the state constitution, depending on its specific wording, doesn't take away the power from the legislature. But it could put a limit on the legislature of some kind. But just because something's in the Constitution, even if it's what we call self-executing, meaning it can be enforced by judges without any so-called implementing legislation, that doesn't mean the legislature loses all of its power. It can still enact laws. They can't contravene the constitutional clause, but they're still, the legislature still has that, remember, reserved plenary power, except as limited. And depending again on how the amendment is drafted, it wouldn't limit most of the legislative power. And also the judiciary retains its common law power. So at least in the environmental law context, we have common law coming all the way back from England about nuisance and pollution, and a number of areas are dealt with. Many of them are now areas of statutory law, but not all of them. So the courts don't necessarily lose that power, nor does the executive. The executive still has the obligation to execute the laws that are emanating from the legislature and to enforce the constitutional provision.
So all of the different branches still maintain their authorities and their functions and their roles. It's just when you add a Green Amendment, they have to perform those functions in compliance with constitutional rights, obligations, limitations.
Exactly.
Okay. Interesting. So you said it, but so state constitutions are interpreted by state courts?
There are some limited circumstances where federal courts can interpret state constitutional provisions, and that's where they're included in litigation that also deals with federal law. Federal courts hear federal law cases, but they can also hear cases that include both federal and state law, number one. And of course, federal courts can hear cases between citizens of different states. So it could be possible that those would include claims about the state constitution. But generally speaking, state courts interpret the state constitution.
Could a federal court come in and reinterpret a state constitutional provision in a way that was contrary to what the state court, presumably the state's highest court, has interpreted it to mean or be?
They could do that. They're not supposed to. And interestingly, if they did that, it would be the state court decisions. That's the law of the state. The federal decision would not be binding on anybody.
Okay.
And normally they wouldn't, a federal judge would not do that.
But we're living in interesting times.
We are.
Right. But they're not supposed to.
Not supposed to.
Okay.
Interestingly, the decision of the state highest court is binding on federal judges on questions of state law.
Okay, so if a state's highest court interprets a state constitutional provision, it is binding on
Federal judges.
federal judges.
Yeah.
Okay. What would you say to the community members working around the nation trying to get passage of constitutional green amendments? What would you say to them if they express concern, well, why should I go to all this effort to get a constitutional green amendment if the federal government can just swoop in and wipe it away?
It would be extremely unlikely because the federal government doesn't have the power to do such a thing. Remember that when the federal Constitution was adopted, it gave certain powers to the federal government, such as regulating interstate commerce. And the effect of a Green Amendment within a particular state, only applying within the state and not affecting any other state, wouldn't affect interstate commerce in any direct way. So such an attempt would most likely be invalid. Possibly if there were effects to other states somehow, Congress could possibly regulate that. But the role of the states in our federal government has been highly protected through structurally each state having 2 senators that look out for the affairs of the states they come from, and the political power of the states through influencing Congress. So theoretically, it's possible there could be some interference with the operation of a Green Amendment, but highly unlikely, if not impossible, that the whole amendment could be interfered with.
So what do you say to the assertion that adding a Green Amendment environmental rights provision to a state constitution is, quote, undemocratic? Because I hear that a lot.
Yeah. It seems to me that it's exactly the opposite of that, because the way that you add a clause to a state constitution is democratic. It involves the representatives of the people, either through an initiative, which is simply gathering signatures up to a certain amount to put it on the ballot, or the state legislature recommending it to a vote of the people, or a constitutional convention, if we ever had any more of those, recommending such a clause to the people, and then the people itself adopting that. And then through, in addition, once it's in the Constitution, through all these mechanisms we've discussed of the state legislature implementing it, the state executive enforcing it, taking care that the laws, including the Constitution, be faithfully executed, and the state judiciary interpreting, particularly state judiciary that's elected, again, not the federal judiciary, is, to me, is the example of popular sovereignty, which is even one step closer to the people than democracy. Democracy, you elect, or republicanism with a small r, you elect your representatives and they do your bidding, hopefully. But this is the people themselves actually voting. I want, in your question, the Green Amendment in our Constitution. So to me, that is democratic. There's one caveat to this. One of the states out of 49, in one of the states out of 49, the people do not vote on constitutional amendments, and that's Delaware, as you may know. And there's a historical reason for that. They only have 3 counties, and the population is not evenly distributed. I understand that's the reason, but the legislature has to pass a proposed amendment twice to get it in the Constitution. But so when I say people vote, there's that one exception.
So many people who are opposed to green amendments suggest, we get a lot of talking points, and many suggest that they're concerned about the use of what they characterize as broad language. For example, the people having a right to clean water and clean air, rather than detailed definitions of what clean water and clean air is, including things like numeric limits on pollution that you might find in a piece of legislation. Can you help our audience understand why the use of overarching language is important in the constitutional context?
The state constitutions are longer and more detailed than the U.S. Constitution, and that leads to some problems. The over-detailed constitutional language often very quickly causes problems because of the fast evolving nature of what's going on in our society. So constitutional language is always thought to be better, sort of general priority language that guides the 3 branches of government in what they do. Yes, it might limit them in various ways, and it might, again, this dual function of positive rights amendments. It can limit what the government does in various ways and require that the government do things in various ways. But the attempt to try to come down to finite detail is almost always fails. And to some extent, we have to rely on the good faith of a state legislature, even if we're critical of the hyper politicization of them, to follow constitutional general directions through more detailed legislative implementation that can be changed pretty quickly, or even direction to administrative agencies to engage in rulemaking that can be changed even more quickly. So you want general guidelines and limits in state constitutions that are then implemented through all these different functions of the 3 branches of government, but according to newly required limits and requirements.
Now, if you have green amendments that are identical and just so you know, there are no Green Amendment proposals that are identical,
not,
but or that are similar, even though the different state courts wouldn't be bound by the interpretation of a neighboring state. Do state courts sometimes look to how other states interpret similar concepts and languages in their constitution to inform how they might interpret their own constitutional provision?
State courts do this all the time, and they do it in non-constitutional cases. It's very common for, in tort cases, accident cases, contract law cases, what have you, to look to what other states do. People forget to do that in state constitutional law, but it is very common. I taught it for years for lawyers not to forget about that. And you're right, of course they wouldn't be binding, but particularly out-of-state cases where the text of the state constitution is identical to the text of the state constitution that's being interpreted now, those can be very important. What's interesting is they often go two different ways, and so the state court has to determine which line of interpretations is more convincing to it. But that's true in tort cases and contract law cases too. At the federal level, the United States Supreme Court has nowhere to look. If it looks out sideways, it ends up in England. And you might look at English cases or French cases, but it's very common in state constitutional law.
So it's helpful to states that are looking to pass their own Green Amendments today to know that there is actually an increasingly well-developed body of law, particularly in Pennsylvania and Montana, who have the first two Green Amendments to have been passed in the United States of America.
Exactly, and of course the idea that the Pennsylvania courts have enforced the clause in various ways could be certainly educational to a state that was considering language similar to the Pennsylvania clause. Same for the Montana clause. Mm-hmm. So even at the stage of considering adopting the text of the amendment, it's important to see what's happened in other cases. And I think in this case, a state would see that state courts in those few states have not run amok and changed the nature of the state based on the constitutional clause.
So now one final set of questions. It's really two questions, but just wondering, how do you view the Green Amendment movement, and do you think that it is a positive use of state constitutions?
Well, I'm not an expert on the Green Amendments, but to me, the advent of this kind of a provision is in a state constitution illustrates virtually all of the lessons about what state constitutions are and what they can be, because state constitutions will continue to evolve long past our lifetime through changes to the text, such as the advent of a Green Amendment, other kinds of amendments that we haven't even thought of at this stage, interpretation of those amendments by the courts of the state, implementation of the amendments by the legislature and the executive of the states. And this interaction of constitutional law, legislative law, executive law, and judicial interpretation is different in the so many ways I've described in the states from what we have at the federal level, that this movement, to me, illustrates the history of state constitutions, used by people to express their views at current points in history.
So Professor Williams, I want to thank you so much for spending so much time with me this morning. I want to remind people of your book. This is a really incredible resource. I'm really enjoying reading it, and it is helping me grow my Green Amendment knowledge. So thank you so much.
I'm so glad to hear that. Thanks for having me.
Want to thank everybody for hanging on. So many of you stayed all the way to the end. And if you stayed to the end, you are part of the free drawing for a copy of Professor Williams' book. We have two people. Shaylin has been doing a random drawing behind the scenes. And so Shaylin, don't know if you finished it up, but before we do that, do we have any announcements? No, we'll go right to the free drawing. Who are our two wonderful winners?
So our two winners are George Fauché and Louise Lears.
Yay! So it's a fantastic book. I hope you're looking forward to digging in. We'll get this in the mail to both of you. So thank you so much. We also will be sending out to everybody who signed up for the forum. Professor Williams gave us a special discount code so that you can get a discount on a copy of the book. So we're going to send that to all those who signed up for the forum and who attended, so you can get it for a little bit less, because it is quite an expensive book. So Shaylin's going to look for some questions, and for those who want to stay on and have a little bit of discussion and Q&A, that's awesome. I do want to remind people that the online community art gallery is up in celebration of National Green Amendment Day, and actually some of the people donated their art so you could purchase them, and of course the sales go back to support the Green Amendment movement. So just want to alert people to that. So Shaylin, do we have some questions?
We do. We've got a question from Kim Stoner in the Q&A here. Professor Williams said that constitutions specify how governments operate. One of the widespread misconceptions is that a Green Amendment would result in lawsuits among private parties, like people suing their neighbors or suing polluting businesses directly. So this frivolous lawsuits argument we often hear. Please give an authoritative response to this.
So thank you for that, Kim. I know Kim faces this challenge often. So to be very clear, Green Amendments, the language in the Bill of Rights section of the state constitution, applies to the government. It is we, the people, holding the government accountable to certain protections and obligations that we, the people, are entitled to. So if we believe there's an infringement on the constitutional right, the challenge is to the government action that resulted in the infringement or the violation of the constitutional duty. You do not have lawsuits between private individuals, between individuals and corporations. It's impacted community members or local government, for example, to whatever state government actor or municipal government actor is causing the infringement, right? So just to be clear there, all the challenges are against government actors. There are times when the actual plaintiff is an individual, is an organization, but sometimes we have seen local government and state government use the amendment to hold one another or themselves accountable.
Wonderful. Thanks so much. And this, right. Okay. Ev Hyde had submitted a similar question, but your response, Maya, also covered what they were asking about, that Green Amendments address the government and not issues between citizens and corporate entities. We have another question from Lorraine Farina. Are you aware of any this might be a little specific to New York State. Are you aware of any pro bono firms that would represent community groups in New York State?
So I want to be very clear, right? In the first instance, Green Amendments are a tool for advocacy, right? And in our advocacy, to get our government officials to proactively, positively ensure that they are protecting the environmental rights of the people and complying with the constitutional duties. And over time, that becomes more and more effective as government officials become aware of their duties and understand fully what it means to comply with them. Just like they proactively work to comply with their obligations with regards to free speech and freedom of religion. Increasingly, that happens with regards to environmental rights. But yes, there are times when we have to go to the courts, and getting into that courtroom can be a hurdle, and we certainly do recognize that. But there are, in every state where there is a Green Amendment, there are organizations that will pursue legal action, whether or not they will do it as sort of a private attorney for a private individual on a pro bono basis, I think is something to be researched in each state. I do know that there are organizations like my Delaware Riverkeeper Network, like Earth Justice. There are some law clinics like the Pace Environmental Litigation Clinic. In Pennsylvania, you have the Widener Law Clinic, perhaps, that will bring legal actions. Whether they will do it to represent a purely private individual, I know Delaware Riverkeeper Network does not, but in some of these other instances, perhaps they do. So if you have a specific issue, we can work to try to connect you with somebody. We do recognize it's a hurdle, but sometimes we can find those resources, and sometimes also there are some really great attorneys out there that want to take on work pro bono because they believe it's powerful and important. And so we can work to try to connect you with some folks in the right circumstances.
Great. We've got a question from an anonymous attendee in the chat. Can the Green Amendment be used to stop affordable housing projects?
So you are not, writ large, you're not going to see a Green Amendment being brought to say there's an affordable housing project that should just be stopped. I think, but we do have to recognize whether it's affordable housing, clean energy, dirty energy, any kind of development project, if the location of the action or activity will result in a serious, significant level of environmental harm that rises to the constitutional level, regardless of the kind or quality of the project, the amendment might be brought to bear to say that that project needs to advance in a way where the project can happen and environmental rights can be protected at the same time. But as just a generic claim that an affordable housing project is an eyesore, I don't like it, it's going to have implications for my property values or my quality of life, those kinds of legal actions are not expected. And in fact, there was an effort along those lines actually in the state of New York in recent months, and it did resoundingly fail. So that is not the kind of claim you're going to see. But if you were to see any kind of project that has had a serious environmental footprint, the amendment might be used to get that project adjusted so the project can happen and environmental rights can be protected at the same time. Hopefully that answers your question, right? As a lawyer, I always try to be very clear, but hopefully I answered your question.
No, and I think the response was great too, because sometimes people will try to shorten a talking point to just that. And so getting more context and actually understanding how the Green Amendment could bolster better development across the board is really helpful to hear. We have a question from Rep. Joanne Ferrari from New Mexico in the chat. Does the federal government have to honor the state Green Amendment and the protections against radioactive waste deposits?
So hi, Rep. Ferrari, our wonderful Green Amendment champion in the state of New Mexico. So honored that you would join us this evening. So really, whether we're talking about the radioactive waste context or any context, we have to remember that a state Green Amendment is going to hold state governmental actors or those whose authority emanates from the state, like municipal, local governmental actors, going to hold them accountable to ensure environmental rights are protected and natural resource protection obligations are met. As Professor Williams and I talked about, the amendment is not going to be able to be used to say to a federal government actor, this is our state constitutional, this is what our state constitution says, you have to comply with it, because the state constitutional language applies to state governmental actors. Now, if you have a federal project advancing that requires a state approval, then when the state is giving that approval must ensure the Constitution is complied with. Does that help?
I thought it was a great response. Does anybody else have any questions? Feel free, you can put them in the chat. Okay, Rep Ferrari said yes, it does help. Feel free to put any questions in the chat or in the Q&A box. I have both open. Can answer anything that comes through.
And otherwise, we really are glad that you joined. You know, Professor Williams, it was a joy to speak with him. He truly, truly, truly is the national expert on state constitutions. His book is a great resource. And all week long, we're going to be celebrating National Green Amendment Day, which is technically on July 13th. But through the art gallery, the online art gallery, we're going to be celebrating it all week. So do look at some of the beautiful poetry and songs and art that were submitted by some of you on this call, and others that are not with us. One more.
Great. It looks like we got one more question in the chat. Is any group working on a green amendment in Ohio, from Ren Austin?
Hi, Ren. We have had interest over the years from Ohio, and I have talked with people, but no one has yet to step fully forward. There is some interest being expressed by the Black Appalachia Coalition, who is also taking on a leadership role in the state of Kentucky, as well as the state of West Virginia. They operate in Ohio, and so they have expressed some potential interest in Ohio. But for now, we don't yet have a movement advancing. But as I always tell people, some of the strongest movements that have come forth, like the one in New Mexico, the one in Maine, the one in Washington, they came forward because a single individual like you joined a program like this or read a copy of my book, The Green Amendment, and called me up and said, how do I make it happen? So if you want to take on a leadership role in the state of Ohio, I would really look forward to connecting with you.
And I think that's a wonderful message to wrap it up on. As Maya said, thanks so much everyone for coming. I will put 2 more links in the chat in case this is your first encounter with Green Amendments for the Generations. I will put a link to become a member for free today so you can keep up with all of the great things going on nationwide. And then I'll also put a link to our active states page so you can see what's going on in your state. And if you don't see anything yet, I have an email address there so you can reach out to us and we can get things started.
Oh, and one final thing, people asked about the recording. They will be on the National Green Amendment Day page. This recording will be there. And also on our action platform, which is our closed community where Green Amendment activists in the state and nationwide we can all communicate with one another without the fear of the larger world watching or grabbing a hold of our information. So you can look for the recording there.
I will go ahead and end our recording here now and close out the webinar. Thanks, everyone. Have a great evening.